Well, it's a very daunting experience arguing before the court. It's very unlike giving a speech because you have to go where the justices want to go. And preparing for oral argument, there can easily be 1,000 different relevant questions that might be asked in an oral argument. And you try to think of many of them as possible. You need someone to help you prepare who's a very good devil's advocate, who's really skeptical about your position. You don't want to be thinking of the hard questions and how to answer them for the first time when you're standing before the court. And the fact that this court is so much more active in asking questions than back when I was a law clerk, it's really astoundingly different. You can, in the course of a 30-minute argument, you can get 60, 70 questions. It's really an extraordinary number of questions. Well, I think one of the most challenging experiences for me, and one that is probably rare, is to be getting ready to argue a case before the court and have the court announce its decision in a case that you had argued earlier in the term, right before you got up to argue. And in my case, it was pretty big. I was getting ready to argue the line item veto case, Raines versus Byrd, in 1997, and the court was announcing its decisions. This was right after Memorial Day. The case was being argued after the usual argument sessions were over because it was expedited. And the Chief Justice says, Mr. Justice Stevens has the opinion in 96-2702, William Jefferson Clinton versus Paula Corbin Jones. Well, there was a hush in the courtroom. And I had argued on behalf of the United States that any litigation against a sitting president should be postponed until the end of his term. And we did not expect that decision to come down until the last day of the term, but here it was, 4 weeks to go. They're announcing the decision. And Justice Stevens' opinion was organized around repudiating each of the arguments I'd made as acting Solicitor General, one after the other. And it was just brutal. And I'm sitting there, 12 feet away, and everyone is watching my reaction as he says. Now, the next argument made by the Solicitor General is even more frivolous than the other arguments. And I'm engaged in sort of denial and bargaining and the stages of grief. And I'm imagining that the Chief Justice Rehnquist must be dissenting from this, and is going to acknowledge wonderful things about my argument in his dissenting opinion, when lo and behold, Justice Stevens mercifully finishes his opinion and he says, nothing. And the Chief Justice looks at me and says, General Dellinger, you may proceed. And I'm thinking, with what? We haven't heard from the 4 dissenting justices yet. And my deputy, Seth Waxman, is pushing me out of my chair to the podium. And I realized that there is no dissenting opinion, that Clinton against Jones has come down 9-0, repudiating the position we had argued. And I have to stand up and start arguing the line item veto case at that moment. That was my hardest moment. And as soon as I got a question, as soon as I was interrupted by a question, as to whether we were challenging the timing or the nature of the senators and our argument that there was no standing, I got that first question and I said, Justice O'Connor, we object to both the who and the when of this litigation. And that was a very bad answer. Because any answer that begins Justice O'Connor, when the question was asked by Justice Ginsburg, is a terrible answer. Justice O'Connor says, that's Justice Ginsburg that answered the question, that asked you the question. So I am mortified that I have done this. But I said, I apologize to both of them, and I said, looking at Rehnquist, and I apologize to you, Chief Justice Souter. And at least I got a laugh and let me recollect my thoughts and think that this lawsuit is no longer my problem. My problem is arguing the line item veto case. And from that point on, I felt pretty good about that argument. But I think that was probably the toughest moment I had before the court. And it's hard, the way the court's calendar works, ever to have a very major case you've argued come down as you're getting ready to argue another major case. So I don't know anybody else that's had quite that experience. Oh, that's what is the high watermark of my arguing before the court? I think arguing the physician-assisted suicide cases as amicus, because we took a position that was in between the parties, where there was a constitutional right to fatal medication, lethal medication, on the one hand, and a notion that there was no liberty interest whatsoever in how your life ends that's good against the state on the other. And we argued an intermediate position that really Irv Gornstein, who was in the Solicitor General's office, really helped me develop. We argued an intermediate position, and Justice O'Connor questioned me very sharply about it, but it was a position that she undertook, that she wound up writing what was essentially the controlling opinion, saying that there really is a liberty interest and a state has to have justification for imposing suffering on people at the end of the life, and that while the present laws forbidding lethal medication were justified, that the court would continue to monitor this. And I felt really good that we had offered the court the position that was, at least for a time, a resolution of that case. I think what I feel good about the physician-assisted suicide cases, Glucksberg against the state of Washington, Bacco against Quill from New York, is that it's the one time where I think we had an influence on the outcome of the case. That particularly arguing as a friend of the court, when the court, a majority of the justices adopted our position and got them out of a box. Well, it was very interesting because it is the first time that questioning a justice has asked me questions literally before I got to the podium. Justice O'Connor jumped on me. And it's a good lesson. She said, "Your position is different from the parties, and it is very, very, very different. And how do you justify that?" As if that was a hostile question. But what's interesting is it was a position to which she was obviously drawn. And she was probing and testing that position, and to seeing what my best answers were that she could use to defend the position that she actually agreed with. So sometimes hostile questions are friendly questions. No, I didn't. I didn't know going in. It was a very hard, the physician-assisted suicide cases was very hard to predict going in. I guess the other experience I had before the court that I feel good about, in addition to all the ones that I don't feel good about, but was the rebuttal in the Exxon Valdez argument. I argued for Exxon that we started out with a $5 billion punitive damage judgment, and it wound up at $500 million. And I had to make a decision on rebuttal whether to go for 2 times compensatory damages or 1 time equal to compensatory damages. And about $1 billion turned on which choice to argue. And that was kind of fun to try to take a guess about where the center of gravity might be on the court by counting up justices at the time. But that was a good experience. Well, there's almost no such thing as spending too much time preparing for a Supreme Court argument. I think probably my best Supreme Court argument was my very first argument when I was a professor at Duke, because I basically took a sabbatical to get ready for the argument. I wrote the critical part of the brief myself up late at night, reading the footnotes in cases, sitting on the library floor back in those days. I think there's no substitute for preparation. There's no substitute for having devil's advocates ask you the hard questions, of having someone who can help you think about which poison to select, when sometimes you have to either carve out exceptions to your argument or stay with a flat principle with no exceptions, and what trouble each of those paths gets you into as an advocate, and which is the best way. And how to think about, the court itself needs an exit strategy in many cases. They want to know what's the best way out of a knotty legal problem. And sometimes each advocate is offering up here's the best way out of this tangle. So you have to think in terms of what an end, not just of what's right or wrong about your position, but what's an end game for the court that's going to be workable. It's going to be workable for lower courts, going to be workable for private actors in the private sector or for government officials or law enforcement. What's a workable solution to this problem that you're offering up to the court that makes sense? But, you know, it's an interesting question. Does oral argument matter? Not in very many cases, but in very many cases, nothing matters. That is, there's going to be a right answer that the justices are going to come to. They've got very good law clerks, so that it's not clear that advocacy plays much of a role in most cases at that level. I think the briefing is clearly more important than the oral argument. But justices have told me and told others and tell each other that the outcome in cases changes every term, in some cases, by what happens at oral argument. Sometimes, for example, you're asking the court to take a step, and the court wants to know where it's going to lead. Where are they going to draw the lines? If they create a cause of action or recognize a cause of action for some kind of injury, is that going to, quote, open the floodgates, or is there going to be a principal line that can be drawn around the hardest cases? I mean, I think that's, I think every term there are a few cases where oral argument really does make a difference. I think it is easier to lose a case at oral argument than it is to win one. That is to say, when the advocate has no good answer to the question, but counsel, if we agree with you and accept your opinion, where does that lead, and where can we cut off the extended consequences of a ruling in your favor? If you don't have a good answer to that, you can make the court very nervous, and that can produce more of a status quo outcome. Well, I think one of the things that's most effective about the Solicitor General's office is the tradition of multiple moot courts, and where the people that are mooting you are people who have themselves argued 15, 30, 50, 60 cases before the Supreme Court. So you have very experienced advocates who are very good at anticipating what kind of questions the justices are going to ask. There's almost no substitute for that. I mean, the hardest thing in private practice is carving out the amount of time that you need to really prepare as adequately as you would like to prepare. The best advice I got about oral argument came from Irv Gorenstein, who heads the Supreme Court Institute at Georgetown and was then in the Solicitor General's office. He said that my problem with oral arguments was that I wanted to advocate like a professor. I was used to having a captive audience for 50 minutes, and that would allow me to set up a series of premises and then to build on the premises to a conclusion, like a pyramid. So it's very lovely to watch and very academic, but the problem is with this court, they cut you off halfway up the pyramid and you're not getting to the conclusion. And then what you need to do is to turn that pyramid upside down. When you get a question, you need to go with the answer and then substantiate or support that answer as well as you can with however much time you're allowed, but you've got to turn it upside down. And after that advice, when I would write out sort of sample answers to questions, I'd often notice that what I would do is take and mark the last sentence of a one-paragraph answer and make it the first sentence, and sometimes reverse the order of all the sentences. You've got to get to the answer yes or no right off the bat, and then defend it as best you can, instead of sort of wanting the court to go along with you as you lead them through a process from premise to conclusion. That's not going to work. And that's something I had to learn to make the transition from being a professor to being an advocate before this court. What do you do about it? I like this. I like to keep, I like to sort of type out answers on a computer so that I can play with them. And then, you know, you don't really look at it during the argument, but the more you play with it, the answer, the more you trim it down. I mean, a lot of oral advocacy before this court is about time management, about trying to compress answers down to the essential nugget because you just don't have the time to engage in professorial exposition. The quicker you can get to the answer, the better. And the court has zero tolerance for not saying yes or no as the first word. You're always better off if yes or no is the first word out of your mouth. It's not always possible, but that's probably the best advice you can give someone.